Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner.
Welcome to Ganga Education, Agreements in Restraint of Trade. Today, we're diving into an absolutely crucial topic for your judiciary and net set exams, Section 27 of the Indian Contract Act. Whether you're prepping for prelims or writing subjective answers, understanding the nuances of this section is, well, completely non-negotiable. So let's jump right in.
Here's our roadmap for today. We're going to start straight from the Bare Act, compare Indian and English laws, look at the exceptions, and break down the landmark judgments. Finally, we'll apply this 1872 law to the modern gig economy, followed by a rapid-fire revision. Let's get to it.
All right, Section 1, Concept and the Bare Act. Let's build a strong foundation by starting with the supreme law of the land.
Freedom of trade is a deeply protected constitutional right under Article 301. You see, the law believes you can't just trade away your freedom to work for money. Contract law acts as a shield here, ensuring nobody uses a dominant position to stop you from earning a livelihood.
To put it simply, trade is buying and selling or practicing a profession. A restraint is any agreement, partial or total, that blocks that free market liberty. Like if someone makes you sign a contract saying you can never practice medicine in your city again, yeah, that's a restraint.
Now, look closely at the exact wording of Section 27. The law is incredibly absolute here. It says, every agreement. If an agreement restricts lawful trade, it is outright void. Zero legal enforceability from the very beginning.
For your exams, you've got to break the Bare Act down into these three essential ingredients. First, you need an actual agreement, or consensus ad idem. Second, a restraint component that limits future freedom. And third, the activity being restricted must actually be a lawful profession or trade. Got it?
Next up, Indian law versus English law. Let's see how our strict approach compares to the country where this law actually originated. This comparison is super important. Under English common law, restraints are perfectly valid if they're deemed reasonable between the parties. But India? We completely rejected that flexibility back in 1872 to protect workers. Here, an agreement is strictly void unless it falls under a very specific statutory exception. No general rule of reason saves it.
Section 3. Exceptions to the rule. So, the big question is, if the rule is that strict, is restricting trade ever legal in India?
Actually, yes. There are specific exceptions. The main one is the sale of goodwill. If you buy a reputed business, you're paying for its customer base, right? So you can legally stop the seller from opening the exact same business next door. Other exceptions include restrictions under the Partnership Act and exclusive distributorships set up by trade associations.
Moving on to restraints upon employees. Guys, this is the most highly tested battleground in this entire topic, employer versus employee.
The courts have drawn a very clear line here. An employer can absolutely stop you from working for a competitor while you're actively employed by them. That's a valid negative covenant. But the second you quit, they cannot enforce that restriction. Post-employment restraints are completely void.
Section 4. Landmark case laws. To score top marks in your judiciary mains, we need to look at how courts apply these rules in real life.
Definitely take mental notes on this. It's pure gold for your exams. You've got Nordenfelt establishing the English rule of reason. But for India, memorize the Naranjan Galikari case. An employee learned a trade secret and tried to quit midway through a 5-year contract. The Supreme Court said restraints during employment are valid. Conversely, in Sri Gopal paper, a 20-year one-sided bond was thrown out as totally unconscionable.
Next up, the fascinating blue pencil rule. Let's think about this. What if you have a massive 100-page corporate contract and just one single sentence violates Section 27?
Does the whole contract go in the trash? No way! The courts use the doctrine of severance. Literally, imagine a judge taking a blue pencil and just crossing out those illegal, restraining words. As long as removing that bad part doesn't destroy the core meaning of the contract, the rest stays perfectly valid. Remember, the law says it is void to that extent only.
Section 5. Modern reality. Let's fast forward this 1872 law into the 21st century. Examiners love testing old laws on modern tech.
Think about modern click-wrap agreements. Companies often try to stop gig workers from multi-homing, like driving for Uber and Ola at the exact same time. Courts are heavily scrutinizing these digital non-compete clauses to make sure modern gig workers aren't unfairly restrained.
Over in the tech world, companies use incredibly complex service bonds for AI developers simply because they have access to highly valuable code. It's a constant balancing act for the courts, protecting a company's trade secrets versus a developer's fundamental right to earn a livelihood.
All right, Section 6, let's jump into our rapid-fire revision to firmly lock these concepts into your exam arsenal.
Memorize these exact key words. This is literally what examiners are scanning for in your subjective answers. Void to that extent. Exception 1, sale of goodwill, the Golokari case for employee covenants, and the blue pencil rule for the Doctrine of Severance. Drop these into your paper and you're golden.
Let's test you with a classic problem-based question, exactly the kind you'll see in the judiciary prelims. Person A sells his bakery and goodwill to Person B, promising not to open another bakery in the same city for 10 years. What do you think? Is this valid or void? The answer? It is valid, because it falls perfectly under Exception 1, sale of goodwill. But remember the catch. The Reasonableness Test actually does apply here under Indian law. The restriction of same city and 10 years has to be considered reasonable by a judge based on the nature of the bakery business.
And that wraps up our comprehensive breakdown of Section 27. If this explainer cleared up your concepts and gave you a solid structure for your exams, be sure to hit that like button. For more such law lectures, subscribe to Ganga Education. Keep studying hard and we'll see you in the next one.
Welcome students to this premium Ganga Education explainer. आज हम इंडियन कॉन्ट्रैक्ट एक्ट 1872 का एक बहुत ही इंपॉर्टेंट और आई शुड से एब्सोल्युटली क्रूशल टॉपिक कवर करने वाले हैं, सेक्शन 27। अगर आप एलएलबी, जुडिशरी या नेट सेट एग्जाम्स की तैयारी कर रहे हैं ना, तो आप ऑलरेडी जानते हैं कि एग्जामिनर्स का ये एब्सोल्यूट फेवरेट एरिया है। सो लेट्स लर्न एग्जैक्टली हाउ टू स्ट्रक्चर अ हाई स्कोरिंग विनिंग आंसर। Okay, let's dive right into this masterclass. On the syllabus today, we're tackling Section 27 through 3 classic problems: a mill closure, employment restraints, and the sale of goodwill. And then we'll wrap it all up with a quick revision and some insider exam tips. Problem number 1, the mill closure. Let's analyze absolute restraints. So here are the facts of the dispute. एक plaintiff और defendant मिलकर एक manufacturing mill run करने का agreement बनाते हैं. But there's a really strict condition attached. The agreement says the mill must remain completely closed for 3 whole months every single year. बाद में the defendant इस condition को challenge करता है, arguing कि ये उसके business करने के right को directly रोक रहा है. This brings us to the core legal issue, the exact question of law you need to identify in your exam hall. Issue ये है, क्या किसी business को periodically यानी हर साल कुछ महीनों के लिए बंद रखने की condition restraint of trade मानी जाएगी? And more importantly, is this void under Section 27? Well, let's look at the Bear Act. Section 27 clearly states that every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. ध्यान दीजिए यहाँ, unlike English law, जो कभी-कभी reasonable restraints को allow कर देता है, Indian law is incredibly strict. कोई भी कॉन्ट्रैक्ट जो किसी पर्सन या एसेट को आइडल बैठने पे मजबूर करे, उसे हमारी कोर्ट्स स्ट्रिक्टली वॉइड मानती हैं। नाउ फॉर ऑल यू जुडिशरी एस्पिरेंट्स आउट देयर, टॉप मार्क्स स्कोर करने के लिए एक लैंडमार्क केस कोट करना बहुत जरूरी है, एंड दैट केस इज खेमचंद मनिकचंद वर्सेस दयालदास बसरमाल। इस स्पेसिफिक केस में भी एग्जैक्टली सेम 3 मंथ क्लोजर की कंडीशन थी, और कोर्ट ने एक क्लियर लीगल प्रिंसिपल एस्टैब्लिश किया दैट कंपेलिंग अ बिजनेस ओनर टू सीज ऑपरेशंस फॉर अ पोर्शन ऑफ द ईयर इज अ डायरेक्ट void restraint of trade. So, let's break this down using the step-by-step IRAC methodology so you know exactly how to structure your answer. Step 1, the rule. Identify that Section 27 voids trade restraints. Step 2, application. Note that a 3-month mandatory closure is a very clear restraint on the facts. Step 3, apply the ChemChan precedent we just talked about. And Step 4, conclude that this condition directly violates Section 27. Meaning, your final definitive exam answer looks exactly like this. Legal position, the condition is strictly void. Rights, the defendant can operate the mill year-round without any restrictions. Outcome, the restraint is completely unenforceable because it goes directly against public policy. Now, what's really interesting about this next section is how the law shifts. Problem 2, employment restraints and negative covenants during service.
Let's imagine this scenario. एक कंपनी स्पेशलाइज्ड फॉरेन टेक्नोलॉजी इंपोर्ट करती है और एक एम्बिशियस एम्प्लॉय को 5 साल के कॉन्ट्रैक्ट पर हायर करती है। कॉन्ट्रैक्ट में एक नेगेटिव कवेनेंट है, मीनिंग अ रिस्ट्रिक्शन, कि वो इन 5 सालों में किसी और के लिए काम नहीं कर सकता। पर होता क्या है? ट्रेनिंग के बाद दैट एम्प्लॉय वांट्स टू जंप शिप। वो हायर सैलरी के लिए मिड टर्म रिजाइन करके एक डायरेक्ट कंपेटिटर के पास जाना चाहता है। सो हियर इज द मैसिव लीगल इशू. Is a negative covenant void if it operates during the term of employment? Think about it. क्या एक active employment के दौरान लगाया गया restriction contract terminate होने के बाद वाले restriction जैसा ही treat होता है? Well, the crucial distinction lies right there. Active service versus post termination. Law कहता है कि during the contract term ऐसे restraints बिल्कुल valid हैं. Why? क्योंकि एक employer obviously अपने trade secrets और specialized training को protect करना चाहता है. So as long as it's not opposed to general public policy, ensuring exclusive service during the contract is perfectly valid. The absolute gold standard Supreme Court judgment you need to remember here is Niranjan Shankar Golikari versus Century Spinning. Supreme Court ने clear rule दिया कि negative covenant during the currency of employment is valid. अगर वो restriction time, area और nature of employment में reasonably restricted है ना, तो it is perfectly enforceable to protect the employer's interests. Let's build that exam writing muscle memory with our steps. Step 1, check the public policy exception. Step 2, look at the facts. There are valuable trade secrets involved and it's strictly limited to a 5-year term. Step 3, apply the Golikari judgment. And Step 4, validate the negative covenant because the employee is actively breaching a midterm contract. So your final answer for problem 2 is clear. The legal position, the agreement is valid and enforceable. The company's rights, they are absolutely entitled to get an injunction. And the outcome is that the employees simply cannot join a competitor during that agreed 5-year term. Okay, moving on to our final and arguably most complex problem. Problem 3, sale of goodwill, global severance, and the blue pencil rule. Picture a massive global transaction. एक world-renowned gun manufacturer अपना business or goodwill heavily sell करता है for £287,500. A buyer अपने इस huge investment को protect करने के लिए seller पे एक 25-year global ban लगाता है on manufacturing guns and engaging in any competing business. पर seller बाद में एक नया business start करता है और buyer use sue कर देता है. यहाँ आपको 2 distinct issues spot करने हैं. First, under Section 27, Exception 1, क्या एक 25 साल का global restraint actually reasonable है? And second, उस overly broad any competing business clause का क्या होगा? Can a court partially enforce an overly broad contract? And this brilliantly illustrates the doctrine of severance. Legal circles में इसे the blue pencil rule कहते हैं. It's literally like taking a blue pencil and crossing out the illegal parts of a contract. अगर illegal part strike out किया जा सके बिना उसके core meaning को destroy किए, तो court uses sever कर देगी यानी काट देगी. In our case, the specific 25-year gun manufacturing ban is valid, but banning him from any competing business of any kind is just way too wide, making it void. इस specific scenario के लिए, the foundational House of Lords case you must quote is Nordenfelt versus Maxim Nordenfelt Kunko. कोर्ट ने होल्ड किया कि उस मैसिव ग्लोबल गुडविल के नेचर को देखते हुए गन बिजनेस पे ग्लोबल बैन एक्चुअली रीजनेबल था. हाउएवर, यूज किसी भी बिजनेस से बैन करना वाज अ मैसिव ओवररीच और इसलिए उस पर्टिकुलर पार्ट को स्ट्राइक डाउन कर दिया गया. लेट्स मैप आउट दिस कॉम्प्लेक्स एनालिसिस फॉर योर एग्जाम. स्टेप 1, apply Section 27 Exception 1 regarding goodwill. Step 2, validate that the 25-year gun ban is indeed reasonable. Step 3, identify the any business phrasing as a clear overreach. And Step 4, explicitly state that you are applying the blue pencil rule to sever the void portion. This leads us to our final conclusion. Legal position? The contract is partially valid through the Doctrine of Severance. Rights? The seller is prohibited from gun manufacturing only. And the final outcome is that the seller is entirely free to go ahead and start other completely unrelated non-competing businesses. All right, let's shift gears for the final sprint. Quick revision and tips. Judiciary exam focus. Here is a highly valuable insider tip straight from an examiner's desk. Always distinguish between restraints during service versus after termination. As we saw in problem 2, a sick timeline say pura ka pura legal outcome completely change ho jata hai. Okay, rapid revision time. Let's lock this in. Section 27, General Rule, restraints are void. The Khemchand case, absolute business closures are invalid. The Golikari case, mid-employment exclusive service agreements are totally valid. And Nordenfelt, use the blue pencil rule to sever overly broad goodwill restraints.
I'll leave you with a final thought to ponder. अगर आज digital e-businesses की कोई physical borders हैं ही नहीं, तो future courts goodwill sale के लिए reasonable local limits कैसे define करेंगी? It's like a giant puzzle for tomorrow's lawyers. Think about it. Thank you so much for joining this Ganga Education Explainer. Keep analyzing and all the absolutely best for your exams.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.